industrial cleaning equipment, in brackets, Southampton, Limited, and intelligent cleaning equipment, holdings 2.
My lady,
Yes.
my lords, I appear for the appellants, intelligent cleaning equipment and Killis. My learned friends Douglas Campbell and Georgina Messenger appear for the respondent, industrial cleaning equipment. There's a list of issues on the appeal at Bundle 2, Tab 1. If I could ask you to turn to that.
Just before we turn to that,
Yes.
we've had an opportunity to consider the various ancillary applications. I think we're all very conscious at times quite tight to deal with all the issues that arise in this appeal. So we propose to consider everything Lib NASA, and then we'll work things out as we go through, I think, rather than us getting involved in disputes at this stage.
We're obliged. But my learned friend and I had discussed the way in which your lady lordships might want us to deal with this matter.
Yes.
And I suggest that I should open the appeal by addressing the court on issues 1, 2, 3 and 6. They're the ones that are the substance of the appeal.
Yes.
And then my learned friend responds on those issues and opens his application for permission to amend, to add issues 4 and 5, and to cross-appeal in relation to issue 5, and makes a substantive argument in relation to those issues.
Well, we'll hear the substantive arguments. We're not going to. We are.
Yes.
Yeah.
And then third, for me to reply in relation to issues 1, 2, 3 and 6, and to respond in relation to issues 4 and 5. And then my learned friend will be able to reply in relation to issues 4 and 5. And that way we'll have done things in the right order, but not had multiple rounds of submissions unnecessarily split up.
Okay with that? Yes, thank you very much indeed.
So then moving on into the issues of in the appeal. Issue 1 in the list of issues is knowledge of registration, whether the proprietor of an earlier right under section 48(1) of the Trademarks Act must know not only of the use but also of the registration of the trademark before the 5-year period of limitation by acquiescence begins to run. If I could ask you to turn to Bundle 1, Tab 2, that's the grounds of appeal. That is addressed in paragraph 3, subparagraph 1, and then paragraphs 5 through to 8 of the grounds of appeal. So those run through to page 19 of the bundle. And I propose to turn to, issue 2, which is the date of registration, which is whether the comparable trademarks in issue were registered such that the earliest date on which the 5-year period of limitation by acquiescence could have begun to run was either the 18th of June 2015, which is my submission, or later dates, and you'll see in the grounds either the 24th or 25th of May 2016 or the 14th or 15th of June 2016, when the EU IPO decided not to refuse the protection and then the next day published that decision, or as my learned friend would put it, granted protection. And there's a substantive difference between us in relation to that. And those issues are dealt with in paragraphs 3.2 of the grounds of appeal, and then paragraphs 9 to 10, which are run from page 19 to page 20. Then there's an issue that's articulated in the respondent's notice as well as in the grounds, which is whether the end of the 5-year limitation period has occurred before the respondent stopped acquiescing in the use of the mark. We say by serving these proceedings shortly after the 21st of September 2021. My learned friend says that the 5-year limitation period hadn't expired because of letters sent on the 2nd of July 2019, 18th of December 2020, and because the claim form was issued on the 24th of May 2021. And you'll find those issues, they arise in the grounds at paragraphs 3.1c to d, where it's dealt with as notwithstanding the threatening proceedings on the 2nd of July, time didn't expire in D. And then in the respondent's notice, which is at tab 3.1 at page 24, and because you may end up reading mainly from the amended draft amended respondent's notice, I would just point out that those issues are dealt with in paragraphs 1 to 2, and then 3 through to 5. There are a couple of unmarked amendments in the draft amended respondent's notice, but they don't really seem to be of any substance. They seem to be more just errors along the way. And there you can see that it said in paragraph 2, Roman 1, that a cease and desist letter on the 2nd of July 2019 brought the period of acquiescence to an end. Then the period of acquiescence ended also on the 18th of December 2020, and then finally when the proceedings were issued on the 24th of May 2021. And then issue 6, my learned friend says isn't really an issue, but it's something that the court needs to look at, which is the effect of the 5-year period expiring. And that's dealt with in the grounds of appeal at Bundle 1, Tab 2, at paragraph 4 on page 16 of the bundle. It says, the questions summarised above go directly to issues 2, 3.2 and 5.4, but in turn lead to the reversal of issues 2, 3, 5 to 8 in the list of issues at the back of the judgment. And then at paragraph 11 of the grounds of appeal, that's dealt with in more detail, so as to set out the paragraphs of the judgment that end up being reversed. With that in mind, it's probably worth taking you to Bundle 1, Tab 7, at page 175 bundle, which is the list of issues for trial. This was a trial in IPEC, the Intellectual Property Enterprise Court.
Sorry.
This is Bundle 1,
Yep.
Tab 7, page 175. So that's the judgment.
I'll put my judgment separately. So if we could use paragraph numbers for the judgment, I'd be grateful.
So internal pages in the judgment, page 81, 82 at the end.
Yes, thank you.
It's the schedule at the end. And if you look at that, you'll see that the issues were broken down into 1, passing off, 2, separately statutory acquiescence, that applied to passing off as well. Then 3, validity of the first defendant's 2015 trademarks, and there at sub-issue 2 was section 48 and article 61, statutory acquiescence. Then 4 doesn't matter anymore, 5, infringement of the claimant's trademarks. And that, over the page, has as issue 4, sections 11, 48 and 61, statutory acquiescence and limit on effects of the trademark. And then issue 6 at the trial was to do with accused acts of the first and fourth defendant in joint tortfeasance. And the one that's relevant here is 6.3, common design, because the first defendant was found liable for jointly with the fourth defendant in relation to the fourth defendant's act of trademark infringement. And then issues at trial 7 and 8 were the appellants, the defendant's counterclaim, the first defendant's counterclaim in relation to the validity of the claimant's trademarks, and secondly, infringement of the first defendant's trademarks. And that's because the claimant's registered trademarks came after the first defendant's registered trademarks, and because, as you'll see when we look at the pleadings, the defendant's case was that the claimant had been trading as a service provider, distributor and so on, and after the defendant entered the market in the UK, it started to move to brand its own products. And therefore, when we talk about returning to the status quo, it's that status quo in 2013-2014, where you had two businesses trading in the UK, one, the claimants, trading as a distributor and so on, under its ICE logo, ICE square logo, and the defendants who were trading in the UK using their capital ICE acronym and the ICE round trademark. The trademark registrations that came after that from the claimant and their use in relation to goods is what's the subject of the trademark infringement and the trademark invalidity proceedings in the counterclaim. So what I propose to do is to show you the overall shape of the claim and the pleadings, only insofar as they're relevant to the issues, but rather than dip in and out of them without having a complete picture, to show you those. And then move on to key dates from the judgment and from the chronology, so that I can then deal with the issues of law in context. And as I say, I plan to deal with those 4 issues, and insofar as those issues break down, I'll explain those, how I'm going to do that along the way. So the claim form, issued on the 24th of May, is at Bundle 1, tab 11. The 2 live defendants are the first defendant on page 185, Intelligent Cleaning Equipment Holdings. And that's the trademark owner, an IP holding company of ICE Group. And then the 4th defendant is ICE Group's UK distributor, Killis Limited. So they distribute and sell products under their brand name of Killis, but the ICE Group products that they distribute are branded ICE with the ICE round wall. And that's where the allegation of trademark infringement comes in. The claim against ICE UK Robotics was not pursued at trial, that's a dormant UK company, and TL Killis and Sons Limited, the third defendant, is the parent company of the fourth defendant, and it didn't do the trade in the goods in question, and therefore the claim against it failed. The amended particulars of claim are at tab 12, starting at page 189. And you'll see at paragraphs 2.1 and 2.2 are the claimant's two trademarks. 2.1, it's a logo mark registered in respect of wholesale, online, retail services, and so on. And you can see the square ICE logo at the top. Those are in class 35, and then in class 37 you have rental of cleaning equipment, machines and vehicles, and so on. At 2.2 you have a later I should have said, by the way, that that trademark was registered with effect from the 23rd of October 2015. That's because it was applied for on that date. Registration was granted on the 22nd of January 2016, but the Act provides, the Trademarks Act provides that the deemed date of registration is then the 23rd of October 2015. That's what's pleaded. And then at 2.2, there's a later trademark which was applied for on the 24th of January 2020, granted on the 8th of August 2020, and therefore has effect from the 24th of January 2020. And that's for a square logo with ICE Clabotics. And that was a peripheral dispute about who was using Clabotics first, who was using Clabotics first. That's not the subject of this appeal. Save that, if the counterclaim is remitted, then that will be the subject of the application to invalidate that from the defendants. At page at page 194, there's the complaint about the first defendant being proprietor of the 685 mark with effect from the 18th of June 2015 and entered on the register on the 25th of May 2016, it is said by the claimant. And that's the first defendant's ICE word mark. And then at 6.2, the figurative mark, the ICE roundel, which is also registered with effect from the 18th of June 2015, and each of those are registered for floor cleaning machines. At paragraph 14, at page 196, there is a combined pleading of trademark infringement and passing off. It used to be referred to as a rolled up plea. And it has its advantages and disadvantages. What it results in is there are some allegations of fact, and then it is said that at paragraph 15.1 over the page at 198, those acts constitute passing off goods and services as and for those of the claimant, or licensed by or authorised by the claimant. And then at 15.2, its use in the course of a trade, a sign which is similar to the trademarks, that's the claimant's trademarks, or either of them in relation to goods or services which are identical with or similar to the services for which the trademarks are registered, such that there's a likelihood of confusion. And it goes on to make other allegations. 15.3 over the page, there's that first allegation being an allegation of infringement under section 10.2 of the Trademarks Act. This is an allegation of infringement under section 10.3, so that the use of defendant signs is said to take unfair advantage of or be detrimental to the distinctive character or repute of the trademark. So that's trademark infringement. And then at paragraph 17, the allegations are combined again. The defendants have infringed the trademarks and committed acts of passing off, whereby the claimant has suffered loss and damage. And then at paragraph 18 is the allegation of common design between the first and or second defendants with the third and or fourth defendants. And that ended up in the judgment as being common design between the first and fourth defendants. And then at paragraph 24 and through to 25.1, there's an allegation that the first defendant's 2015 trademarks, the ones ending 685 and 671, are invalid, and here we're particularly concerned with section 47.2b and 54a of the Act, and that's because that's an allegation that the claimant's earlier right in passing off gives rise to a right to prevent normal and fair use of the defendant's trademarks, and as a result of that, they're invalid. And it's that claim that the defence of acquiescence under section 48 is raised in relation to. That's dealt with in the amended defence and counterclaim, paragraph 10.2. That's at tab 13, page 210. .2, the allegation is the first defendant's trademark, namely the ICE word mark ending 685 and the ICE roundel mark ending 671, have been registered in respect of 4 cleaning machines with effect from the 18th of June 2015, having been in continuous use in the UK in relation to those goods since they started to be imported into, offered for sale and sold in the UK in about 2013, in relation to which the 6-year limitation period has expired. You'll see later that there's a pleading of English Limitation Act defence in relation to acts that are that old, but that runs in parallel with section 48. At paragraph 10.5, it's pleaded that those trademarks, international legislations, designate a list of countries for protection that include Australia through to the EU, and then Singapore. They were protected in the EU and hence the UK with effect from their registration at the International Bureau on the 18th of June 2015 under those EU trademarks W01 256 685 and EU trademark W01 260 671. So you'll see that the trademark numbers flow through from the international registration to the EU registration and then ultimately to a comparable trademark IR in the UK. And that's what the last sentence of that paragraph deals with. They were re-registered as comparable trademarks in the UK on the 31st of December 2020 with the effect from the original date of protection in the EU. And then at paragraph 12, there's a response to the alleged particulars of trademark infringement and passing off that we looked at before. So this is a response to the whole of paragraphs 14 to 17. And it said, the act of which complaint is made in those paragraphs do not amount to trademark infringement or passing off for the following reasons. Paragraph 12.2 is a defence under Section 11.1 of the Trademarks Act, which then got amended to Section 11.1a of the Trademarks Act, and that's a defence on the basis of having a registered trademark. That doesn't apply if the registered trademark is invalidated, so that it doesn't come back to life unless the Section 48 defence succeeds. Then in paragraph 12.1, the alleged earlier right in passing off relied on by the claimant in the particulars of claim. So the claimant, as proprietor of the trademarks, and the
You're in 12.3 actually.
Sorry, did I speak?
Don't worry, 12.3.
Paragraph 12.3. The claimant, as proprietor of the trademarks and the alleged earlier right in passing off, relied upon in the particulars of claim, has acquiesced for a continuous period of more than 5 years in the use of the defendant's registered trademark, namely the defendant's ICE word mark and the defendant's ICE roundel mark in the UK, being aware of that use, such that in accordance with Section 48(1) of the Act and or Article 61 of the EU Trademarks Regulation, there has ceased to be any entitlement on the basis of the trademarks or the claimant's alleged earlier right in passing off, A, to apply for a declaration of the registration of the ICE word mark and or the ICE roundel as invalid, or B, to oppose the use of the ICE word mark and or the ICE roundel in relation to the goods in relation to which they are registered. So that's a shorthand for the floor cleaning machines referred to earlier. And so that is a pleading of a defence to the application to invalidate those marks and the claim in passing off or any other claim which seeks to stop the use of the ICE word mark or the ICE roundel mark in the hands of the claimant. Sorry, the defendant's use of it and any claim brought by the claimant. And then paragraph 12.4 deals with knowledge by reference to the facts that were available to the defendants at the time they pleaded their defence, so that in paragraph 12.4a it's pleaded that the claimant must have known about the use and or the registration of the ICE word mark and the ICE roundel mark.
Do we need to get into this because we've now got the judge's findings of fact?
And we now have the judge's findings of fact in relation to knowledge. What we do need is subparagraph D, which provides alternative versions of the period of acquiescence. It says 5 years from the 18th of June, or before a date in May 2016, or before the date up to which the claimant solicitor achieved service of the proceedings in late September 2021. This is paragraph 12.4d. And then, or when the claimant solicitors sent a letter enclosing but not serving an issued claim form on about the 22nd of June 2021. And that was as far as I needed to take you in that pleading, other than just to point out in passing at paragraph 21 that on page 219 there's a separate plea of section 2 of the Limitation Act, which was dealt with in the judgment in the normal way. And then there's a counterclaim, and I just need to show you the paragraphs. So how the counterclaim works is that on page 221, paragraph 28, the counterclaim was that since about 2016, so after the registration of the defendant's 2015 trademarks, the claimant had been selling and offering to sell and threatening to sell and offer floor cleaning machines now and similar equipment that are marked with the name ICE. So this is a different thing from selling products as a distributor called ICE, branding products ICE. And Then at 28.2, there's reliance on the website and certain of those products being sold through the website. And then at 28.3, there's an allegation that by 2020 and 2021, the claimants had escalated its infringement of the ICE word marks and introduced an ICE range, and that, paragraph 28.6, that was engaged in after the first defendant's representatives had sent a letter on the 26th of July 2018 warning about such things. So it's not a case of the defendants trying to shut the claimant's business down, non-standing business down. It's to stop the new departure into products which clash. And that's not a matter in front of you, but it suggested, I think, on the other side, that the defendant's position somehow goes beyond trying to get back to the status quo. That's not the aim of the operation. Then the reply and defence to counterclaim at paragraph 12, so this is at page 229, tab 14. Subject to some amendments, it's always been denied that the claimant has acquiesced in the defendant's use of the ICE word mark and the roundel mark as alleged. It was originally alleged that the claimant wasn't aware of those activities in the United Kingdom until around March 2019, as set out in the pre-action correspondence. But because of what turned up on disclosure and what Mr. Bresnahan said in his evidence, that positive allegation of lack of knowledge was withdrawn, and instead in paragraph 13, it's admitted that Mr. Bresnahan, the claimant's managing director, was aware that Worldwide Cleaning Support, previous distributors, were selling ICE Group products in the United Kingdom branded with the word ICE and or the defendant's roundel mark from in and around July 2014, and it was denied that all along that between 2013 and June 2016 that the claimant's directors were aware of the registration of the trademark or the application for registration, and accordingly the previous denial of knowledge of use was deleted. And then in paragraph 14, it denied that the claimant was notified of the existence of the ICE word mark or ICE roundel mark as alleged. This was an allegation that when they applied to register their own mark, surely they must have found ours. It was denied, and that denial continued to trial and held that the executive chairman, Mr. Marston, was an honest witness, and there was nothing to gainsay that denial. And you can see at the last sentence of that paragraph, 14, pleading of the law, a proprietor of an earlier mark must know of both the registration and the use of the later trademark in order to have acquiesced pursuant to section 48(1). And it's that position that's the subject of this appeal. And then, just so you get the complete picture, in paragraph 32 on page 233, you'll see a similar plea and change of position in relation to knowledge, alleging that the claimant became aware of WCS's was selling the ICE Group products in the United Kingdom under the sign ICE in and around July 2014, however wasn't aware of the trademark registrations until 20th of July 2019, and that's connected to the allegations of knowledge in the counterclaim. And then if I could just ask you to turn back to page 230. This is the pleading in relation to when knowledge was obtained. The ICE word mark was registered on the 25th of May 2016. The ICE roundel mark was registered on the 14th, crossed out, 15th of June 2016. Claimant first complained of the activities on the 26th of July 2019 via a cease and desist letter. Now, in fact, the 26th of July is the date of the first defendant's representative's response. That letter was, the outward letter from the claimant was sent on the 2nd of July 2019, and it said that the acquiescence terminated on that date, and that's what gives rise to issue 3. So it said those dates are less than 5 years from the registration of the mark. So those are the pleadings. In the judgment, which is at tab 7, I shall use the paragraph numbers and pages. The facts I've outlined about the claimant and the defendant are recorded in a little bit more detail in paragraphs 2 and 3, and then the marks in issue are laid out in paragraph 7, and you can see what the judge has done is set out the marks or signs that are in relation to which the claimant passing off was advanced in rows 1 and 2. So each says, C says goodwill subsisting. And then 3 and 4 are the first defendant's trademarks. And then 5 and 6 are the claimant's subsequent registered trademarks. And 6, 7 and 8 are all about probiotics and robotics. That's robotics. And then the finding about the claimant's knowledge is at paragraph 15 on page 7 of the judgment. There's no need to take you through all the details of the factual findings to deal with these issues, but it may be useful to turn to tab 6, which is a largely agreed chronology. And the differences between the parties are in colours, but there are also references to the materials.
Is this the one that we received this morning, an updated, amended one?
I didn't know there was an update this morning,
Perhaps it was
so I
Friday.
apologise.
Well, I'm afraid we don't know anything about it.
No.
May I take instructions on that?
It may be simply that it hadn't made my bundle and it's put into my bundle today.
Right. The copy I have has got updated written in the top left-hand corner.
Yes.
Just that word.
Yes.
Mine doesn't, so that probably is within friends. Never mind.
We'll make sure that mine is
Please.
updated.
Thank you.
My recollection is there weren't huge changes, and it was dealt with between solicitors. What you see there is that there's an attempt to set out the timeline, both of the key events and sometimes the changes in legislation. So that, for instance, in 2008 and 2009, the 2009 trademark regulation comes into force, and at around the same time, in November 2008, there's an entry into force of the Trademark Directive 2008-95, which isn't included. So there's changes in the law coming through, or the relevant legislation, which we try and address in our submissions as we go along. The key dates that I wanted to draw your attention to is that Ice Group products begin being imported into the UK on the 1st of June 2013, and that's paragraph 3 of the judgment. The judge reaches the conclusion that the relevant date for assessing passing off is June 2014, and by this date the claimant had accrued substantial national goodwill associated with the trademarks ICE and the ICE logo. And then in July 2014, the claimant became aware of the ICE Group's then exclusive UK distributor Worldwide Cleaning Services selling in the UK products under the first defendant's ICE sign and ICE logo. And that coincides with the exchange of emails between the claimant's executive chairman, Mr. Marston, and Simon Chen of ICE Group, when there's talk of visits and collaboration. So it's that kind of documentation and external interaction gives rise to the kind of knowledge of use in this kind of case. Then on the 18th of June, the first defendant's 2015 trademarks, that's the word mark and the ICE logo, are protected as international trademark registrations. So could I ask you to turn to those, which are in bundle 2, at tab 8, starting at tab 8. So tab 8 is the international trademark ending 685 for the word mark ICE. And you'll see at entry 151, the date of registration is the 18th of June 2015. At entry 732, it's in the name of Intelligence Cleaning Equipment Holdings Company Limited, first defendant. And as well as having the mark identified 540 as ICE, and the classification of goods, floor cleaning machines identified at 511. At 822, the basic registration is identified as taking place in the US on the 7th of April 2015. And at 832, the designation includes EM, which is a EU trademark. That's how the rights come to be created by registration at WIPO. And it's the effect of that date of the 18th of June 2015 that is the subject of issue 2. Appeal. Then at tab 9, page 489, you have the international trademark ending 671. Again at 151, date of registration is 18th of June 2015. It's in the name of first defendant, 732, and at 540, the mark is the ICE roundel logo. At 511, the goods and services over the page are floor cleaning machines. And again, the basic registration at 822 is the 7th of April 2015. And the designations under the Madrid Protocol, including EM, which is a EU trademark. Now those, followed immediately in the chronology, give rise to the EU trademark registrations as international registrations at bundle 2 tab 10, page 51. can see the numbers translating through. So that's the ice train trademark 685, ending 685. And you can see that an informational timeline is given where the mark having been registered at WIPO on the 18th of June 2015, the international registration was received on the 23rd of July 2015. It's under examination on the 23rd of July 2015. There's a start of an opposition period on the 24th of January 2016. No oppositions received, and on the 24th of April 2016, there's the end of the opposition period. And then on the 24th of May 2016, the international registration is accepted. And when we look at the registration, we'll see that that means that no refusal has been transmitted to WIPO. And that's the difference of substance between my learned friend and I. That on our side, we say that's something that can prevent registration from continuing, but it's not something, an event that gives rise to the registration. It's no refusal, and the WIPO regime, the Madrid regime, is designed to give rights from the international registration date, and it's expressly dealt with in that way, so that you end up with the registration date below as being the 18th of June 2015, and the designation date being the 18th of June 2015. Below the goods and services, as you'd expect, the 7 floor cleaning machines. And then over the page, well as the publication on the 18th of June 2015, which anyone can get their hands on an electronic database of the international trademark registration, then there are 2 publications by the EU trademark registry. First is on the 24th of July 2015, and the second is on the 25th of May 2016.
I beg your pardon, where do we find those?
Those are on page 53,
Right.
under publications.
Yes, thank you.
So you'll see that those are each the day after. Sorry, the second one is the day after the IR is recorded as accepted, that there's been no refusal, and that explains the difference between my grounds of appeal and my learned friend's respondent's notice. He says the date of publication somehow matters. We say, if you're saying that registration somehow doesn't have the effect that the Madrid Protocol says, because there's been no notice of refusal, then it's the date of the notice of refusal that would count in those circumstances, not the publication date. And that actually may make a difference, because the claim form was issued on the 24th of May 2021. So in relation to the word mark, that may make a difference at that point, because that would then be a day late. Then at tab 11, at page 55, there's the EU trademark ending 671. It says ICE above it. It has a similar timeline, but ending up with different dates, so that you end up with the IR accepted, which we submit means no refusal, on the 14th of June 2016. But you see, under the trademark information, the registration date is 18th of June 2015, and the designation date is the 18th of June 2015. And in the left-hand column, the type is figurative, so that over the page under graphic representation, which is the title, the bottom half of the page, you get the roundel. And then at 7, you have the goods identified as floor cleaning machines, course, the owner is Intelligent Cleaning Equipment Holding Company Limited. And then over the page, a couple of pages, at page 58, you have the same type of publication information. So again, you have three publications. The publication of the international registration on the 18th of June 2015, and then you have publication on the 14th of August 2015, which is the day after examination starts, and the 15th of June 2016, which is the day after no refusal has taken place. And with that, I can turn to the legislation. Now, the legislation is the starting point of issue 1, but it may help if I explain to you where I'm going to go on issue 1, so that how it's broken down. I break it down into 4 stages. First, the UK and EU legislation, with a commentary in relation to its purpose, and for that, the Court of Justice case of High-Tech is useful, which this court then relied upon in Coombe. Don't plan to take you through the same passages saying the same thing in Coombe, because it amounts to the same explanation of purpose. And then second, to deal with the case law on limitation by acquiescence under the EU TM regulations that applied, because, and there's 2 reasons for that. One is because we have this distinction between the approach adopted in the Board of Appeal and General Court on appeal from the Board of Appeal, and the approach adopted by the Court of Justice under the directive in Budvar, or at least the words used. And also because at the date when the acquiescence period expired in this case, the marks in issues were EU TM IRs, so international registrations. So the regulation governed the acquiescence defence at the date we say the time ran out. Then we had IP completion day withdrawal from the EU and the creation of comparable trademarks, and then we have the provisions of Schedule B of the Trademarks Act. In our submission, it would be incredibly surprising if there was a change in law between the two. That can't have been the intended purpose. We say the law is the same between the two. Thirdly, I propose to deal with the case law under the Trademark Directive, which the judge at first instance applied. And fourth, I deal with whether the Court of Appeal is bound by rules of precedence from the determining that knowledge of the registration is not required under section 48(1). So, turning to the legislation, my suggestion is I try and skip through it quickly. But if anyone thinks I'm doing it too quickly, please say slow down, Sybil, because I'm not trying to bamboozle quickly through it. So that starts in Authorities Bundle A2.1. We apologise about the way the numbering works. There was a miscalculation about the possibility of using double-sided printing, and then discovering that wasn't preferred. And therefore, those 2 bundles had to be split. So, my learned friend and I have gathered together the relevant provisions in, or I should say my learned friends and I have gathered together relevant provisions in tab 19 from Westlaw. All but one are up to date. The one that isn't up to date is not for this part of the case, but is section 56, because that's the provision that was in force on the 26th of December 2022, up to then. So it's not a mistake. But for the avoidance of disorientation or having the amount of information available limited, we've also included at tab 31 from page 423 onwards the copy of the Trademarks Act from Curley's Law of Trademarks, which is pre-Brexit. And at tab 32, the unofficial consolidated version of the Trademarks Act as amended from the UK IPO's legal section with the usual caveats that it's not official and so on. But as far as I understand it, there's no dispute between the parties as to these are right.
I hope it's more accurate than the UK IPO's version of the Copyright Act, which is extremely unreliable.
And I don't know the answer to that, except that Westlaw has a mistake in the provision about
Westlaw is not entirely accurate with these materials either.
Indeed. And I know that I've got a copy of Morgan on trademarks, but Morgan Trademarks specifically says it's using the UK IPO version. So, I'm sure that we would have identified the problem if there was any problem in the sections that we are.
I think it's less of an issue with the Trademarks Act.
Yes. So, try and take you through the Act by picking up all the relevant sections to this argument now, knowing that we're going to come back to them for some of the other things, particularly in the respondent's notice. So, Section 2 provides that a registered trademark is a property right obtained by registration of a trademark. This is at page 2, at tab 19. Obtained by the registration of a trademark under this Act, and the proprietor of a registered trademark has the rights and remedies provided by this Act. Subsection 2 is a section that, as my Lord Justice Arnold know, has a history, similar provisions in Section 2 of the Trademarks Act 1938 and so on. But no proceeding shall lie to prevent the recovery of damages from the infringement of an unregistered trademark as such, but nothing in this Act affects the law relating to passing off, and that arises in relation to the amendments to respondent notice. Then, in Section 5, grounds for refusal of registration, these are relative grounds because they're relative to other trademarks. And Sections 5, subsection 1, starts with the trademark shall not be registered if, and then it's by reference to being identical with an earlier trademark, and the goods and services for which the trademark is applied for are identical to the goods and services. That's called double identity grounds for refusal. Subsection 2, trademark shall not be registered, and there has to be a likelihood of confusion, different sets of parameters. The reason that we're looking at this section is because when we turn over to subsection 4, the trademark shall not be registered if or to the extent that its use in the United Kingdom is liable to be prevented, and then A, by virtue of any rule of law, in particular the law of passing off, protecting an unregistered trademark or other sign used in the course of trade. And then after AA and B, a person thus entitled to prevent the use of a trademark is referred to in this Act as the proprietor of an earlier right in relation to the trademark. So that's where the definition of earlier right is found. And you'll see in subparagraph 4a, there's a condition in subsection 4a for capital A. And that condition at 4 capital A is the condition mentioned is that the right to the unregistered trademark or other sign were acquired prior to the date of application for the registration of the trademark issue in this case. Then at section 9 on page 7, subsection 1, the proprietor of a registered trademark has exclusive rights in the trademark which are infringed by use of the trademark in the United Kingdom without his consent. The acts amounting to infringement, if done without the consent of the proprietor, are specified in subsections 1 to 3 of section 10, and then 1A says there's some more provisions as well. Those provisions we don't need to look at, but they involve use of a sign that's identical to the trademark in relation to goods which are identical to those for which the mark is registered. It's called double identity infringement. That's section 10.1, and then you have section 10.3, infringement that depends on the likelihood of confusion, and section 10. Sorry, so it says section 10.2, it depends on likelihood of confusion, and section 10.3 that depends upon unfair advantage or detriment to the distinctive character or repute of the mark. And I mention those only because those were mentioned in the pleadings. Then at subsection 3, the rights of the proprietor have effect from the date of registration, which is in accordance with section 40, subsection 3, is the date of filing of the application for registration. And we'll come on to section 40, subsection 3. And then there's a proviso that no infringement proceedings may be begun before the date on which the trademark is in fact registered. So that means you have rights that are date back to the date of the application for registration. Subsection 11.1, as it currently stands, is that a registered trademark is not infringed by the use of a later registered trademark where the later registered trademark would not be declared invalid pursuant to section 47.2a, 2g, or section 48.1, which we're going to come on to discuss. Notice that's a later registered trademark by the use of a later, so it's infringement of a trademark by a later registered trademark. That doesn't apply to rights in passing off. Just so that you understand how it arises in the pleadings, if you turn to tab 31, page 433, you'll see the old version of that section. Oh, I beg your pardon, that's in page 42.
Sorry, 41, you say?
Tab 31, page 433.
Thank you.
A registered trademark is not infringed by the use of another registered trademark in relation to goods or services for which the latter is registered. But see section 47.6, the effect of declaration of invalidity. So because a declaration of invalidity gets rid of the mark ab initio, you can do so, you don't get the defence if your mark is declared invalid. Turning back to bundle 9, bundle 2.1, A 2.1, tab 19. This is the provision that applies in relation to domestic registered trademarks. Section 40, subsection 3, a trademark when registered shall be registered as of the date of the filing of the application for registration, and that date shall be deemed for the purposes of this Act to be the date of registration. So that's a deeming provision that makes the date of application the date of registration for the purposes of the Act, apparently on its face, the whole of the Act. As it turns out, for Madrid Protocol marks, the way in which that's dealt with is in the Madrid Protocol itself, and then in Schedule 2B. Then we come to the live section subject to debate at page 15. where the proprietor of an earlier trademark or rather earlier right has acquiesced for a continuous period of 5 years in the use of a registered trademark in the United Kingdom, being aware of that use, there shall cease to be any entitlement on the basis of that earlier trademark or other right, A, to apply for a declaration of the registration if the later trademark is invalid, or B, to oppose the use of the later trademark in relation to the goods or services in relation to which it has been so used. So that's the wording of the Act that was reproduced in the pleading that we looked at. The pleading said in relation to the goods for which the marks are registered, being an allegation that those the mark was used in relation to those goods. The facts are set out in the rest of the pleading. That section, as my Lord Justice Arnold described it in Coombe, contains a single condition in paragraph 1 and then 2 consequences in subparagraphs A and B. This issue 1 is about the exact meaning of the single condition. My learned friends, issue 5 is about the effect of the second consequence. Just turning to the single condition under our issue 1 at the moment. It said in the judgment that it would be perverse to interpret being aware of that use as not incorporating awareness of both the use of the mark on the marketplace and the fact of its registration. In my submission, with the greatest of respect, that doesn't give any reasoning for that linguistic interpretation. Neither does the assertion that you could have said being aware of the use of the later trademark. It would have given the same point, because the question is the trademark registered? In my submission, on its language, and particularly when we come to turn to look at the purpose, it's clear that the first part of the section refers to the proprietor of an earlier right acquiescing for a continuous period of 5 years in the use of a registered trademark. So the trademark has to be registered and the acquiescence has to be in the use of it. But the awareness has to be in relation to the use on the marketplace. As it's put in Ghibli trademark, if the legislature wanted to say being aware of the registration and the use, it could have used exactly those words. As to, in brief, section 48(1)(b), the ceasing of the entitlement to oppose the use of the later trademark in relation to goods or services in relation which it has been so used is unlimited linguistically in its scope. You just can't oppose the use anymore, having acquiesced for 5 years, which makes sense. But it clearly covers the earlier right relied upon, because otherwise it doesn't have the combined effect that the legislature intended, which is coexistence by acquiescence, both of the registrations and the use in the marketplace. Or in this case, coexistence of the earlier right with the registration and their use in the marketplace. And then subsection 2 says where subsection 1 applies, the proprietor of the later trademark is not entitled to oppose the use of the earlier trademark, or, as the case may be, the exploitation of the earlier right, notwithstanding that the earlier trademark or right may no longer be invoked against its later trademark. So when it's use of an earlier trademark, that's use of the particular sign in question in the trademark in relation to the goods or services for which it's registered. When it's exploitation of an earlier right, it's the exploitation of that right in relation to the activities which that right subsisted in relation to. And that's what gives room for the counterclaim in relation to goods when there's a prior right in relation to a service activity. But any details of that would then have to be sorted out in the remission to the Court of First Instance. Now, there are equivalent provisions in each of the trademarks directives and each of the parallel regime for community trademarks in the regulations. They've been through, each of them has been through 3 iterations. What I propose to do is to show you briefly the first directive and the last directive, because things have been rearranged a bit, and then the first regulation and the last regulation. I will try and do that as quickly as possible. So this is bundle A2.1 tab 23. Sorry, yes, tab 23. Is the first directive, and our Trademarks Act implemented that first directive. Start off on page 69, which is the last recital on the page, and if you take it from me, that's recital 7. Counting through, it may be helpful to write 7 against it. And that explains in 3 chunks, which I'll read out therefore in 3 chunks. Whereas attainment of the objectives at which this approximation of laws is aiming requires that conditions of obtaining and continuing to hold the registered trademarks are in general identical in all member states. Then the next whereas talks about listing examples of signs, and then the third whereas the grounds for refusal of invalidity concerning a trademark itself, for example, the absence of any distinctive character, or concerning conflicts between marks and earlier rights, are to be listed in an exhaustive manner, even if some of these grounds are listed as an option for the member states, which therefore will be able to maintain or introduce these grounds in their legislation. The reason I mention that is because the earlier right basis of section 48 is expressed as being optional. Then the penultimate recital on page 70 is recital 11, and that's about the acquiescence, what the directive calls limitation by acquiescence. Whereas it is important for reasons of legal certainty and without inequitably prejudicing the interests of a proprietor of an earlier trademark, to provide that the latter may no longer request a declaration of validity, nor may he oppose the use of a trademark subsequent to his own, which he has knowingly tolerated the use for substantial length of time, unless the application of subsequent trademark was made in bad faith. So that introduces 2 statements of purpose. First, for reasons of legal certainty, and second, without inequitably prejudicing the interest of the proprietor of an earlier trademark. And then there's the provision that's being explained. That is then found in, oh no, I beg your pardon. I have to first of all take you to Article 4, which is entitled Further Grounds for Refusal or invalidity concerning conflicts with earlier rights. And you'll see that subarticles 1 and 2 deal with earlier trademarks, and subarticle 4 deals with any member state may further provide that a trademark shall not be registered, or if registered shall be liable to be declared invalid, where and to the extent that, and then if we turn over to B, rights in a non-registered trademark or other sign used in the course of trade are acquired prior to the date of application for registration of the subsequent trademark. It deals with priority. And that non-registered trademark or other sign confers on its proprietor the right to prohibit the use of a subsequent trademark. The use of the trademark may be prohibited by virtue of an earlier right, other than the rights referred to in 2 and 4b in particular, and then there's some other earlier rights. And so we can see that Article 4.4b is referring to an earlier right as well. And then on page 75 is Article 9, which deals with limitation in consequence of acquiescence in wording that's very similar to section 48, where in a member state the proprietor of an earlier trademark, referred to in Article 4.2, has acquiesced for a period of 5 successive years in the use of a later trademark, whilst being aware of such use, he shall no longer be entitled on the basis of the earlier trademark either to apply for a declaration that the later trademark is invalid or to oppose the use of the later trademark in respect of goods or services for which the later trademark has been used, unless the registration of the trademark was applied for in bad faith. And then the optional provision in Article 9.2, any member state may provide that paragraph 1 shall apply mutatis mutandis to the proprietor of an earlier trademark referred to, or an other earlier right referred to in Article 4.4b. So that's the source for section 48.1 as it applies to earlier rights. And it has the 2 limbs introduced from Article 9.1 by virtue of mutatis mutandis with all necessary changes. And then Article 3 provides the reciprocal coexistence as well. Then turning to, I propose to skip tab 24, which is the Trademarks Directive 2008/1995 EC, because its provisions are equivalent in all respects. In my submission, the provisions of the 2015 Trademark Directive are also equivalent in all material respects, but I should show them to you because things are slightly rearranged. You turn to page 93, you'll see that there's recital 29, which is equivalent to the recital that we looked at before, slightly different wording. It is important for reasons of legal certainty to provide that without prejudice to his interest as a proprietor of an earlier trademark, the latter may no longer request a declaration of invalidity or oppose the use of a later trademark subsequent to his own mark, of which he has knowingly tolerated the use for a substantial length of time, unless the application for a subsequent trademark was made in bad faith. So that provides the same 2 purposes, the reason of legal certainty and not prejudicing the interests of the proprietor of an earlier trademark. And then on page 99, we have Article 5, relative grounds for refusal, and on page 101, Article 5, subarticle 4a, any member state may provide that a trademark is not to be registered, or if registered is liable to be declared invalid where, and to the extent that rights to a non-registered trademark or to another sign used were acquired prior to the date of application for the registration of the subsequent trademark or the date of priority, and that non-registered trademark or sign confers on the proprietor the right to prohibit the use of the subsequent trademark. And then again, in Article 5.4b, there's a reference to an earlier right other than the rights referred to in Articles 2 and point 4a, making it clear that earlier rights encompass those ones. And then on page 103, there's Article 9, which deals with preclusion of a declaration of invalidity due to acquiescence. So, sub-article 1 provides that the proprietor of an earlier trademark, as referred to above, has acquiesced for a period of 5 years in the use of a later trademark registered in the member state. Whilst being aware of such use, the proprietor shall no longer be entitled on the basis of the earlier trademark to apply for a declaration that the later trademark is invalid in respect of the goods. So that only deals with invalidity. Then sub-article 2, article 9.2, provides that a member state may provide that paragraph 1 of this article is to apply to the proprietor of any other earlier right referred to in article 5.4a and 5.4b. So that gives you in relation to passing off. And then if you turn to article 18 on page 109, intervening rights of the proprietor of a later registered trademark as a defence in infringement proceedings. In infringement proceedings, the proprietor of a trademark shall not be entitled to prohibit the use of a later trademark where that later trademark would not be declared invalid pursuant to Article 8. And 2, in infringement proceedings, the proprietor of a trademark shall not be entitled to prohibit the use of a later EU trademark where the later trademark will not be declared invalid pursuant to Article, and then we have Article 54.1. Sorry, and so and then we move on to the regulation. Article, this is Bundle A 2.1 tab 26. On page 126 at the top, whereas the right in the community trademark may not be obtained otherwise than by registration, and registration is to be refused in particular if the trademark is not distinctive, it is unlawful or it may conflict with earlier rights. Then on page 130, we have relative grounds for refusal. Sub-article 4, the opposition by the proprietor of a non-registered trademark to another sign in the course of trade, more than mere local significance, will not be registered where and to the extent pursuant to legislation of the law of member state governing sign. And then B, the sign confers on the right on to prohibit the use of the subsequent trademark. And then Article 52, 1C, on page 184, relative grounds for invalidity. A community trademark shall be declared invalid on application to the office. C, where an earlier right, as referred to in Article 84, and the conditions set out in that paragraph are fulfilled. And then at Article 53, sub-articles 1 to 3, limitation in consequence of acquiescence, where a proprietor of community trademark 1 has acquiesced for a period of 5 successive years in the use of a later community trademark, whilst being aware of that use, he shall no longer be entitled on the basis of the earlier trademark declaration of invalidity to oppose the use of the later trademark. And then in sub-article 2, where the proprietor of an earlier national trademark or another earlier sign referred to in Article 8.4 has acquiesced for a period of 5 successive years in the use of a later community trademark in which the earlier trademark or other sign is protected, being aware of such use, he shall no longer be entitled on the basis of the earlier trademark or other earlier sign either to apply for a declaration that the later trademark is invalid or to oppose the use of the later trademark in respect of the goods or services for which the later trademark has been used. So that's the equivalent of section 48 in relation to earlier rights, such as passing off. Then I propose to skip over CTM Regulation 2007/2009, whose provisions are equivalent. I don't think there's any dispute about that. And then turn to to Regulation 2017/1001, which is at bundle 2.2, tab 28, at page 295. On page 296, sub-article 9 refers to a right in an EU trademark should not be obtained otherwise than by registration, and registration should be refused if the trademark is not distinctive, if it is unlawful, or if it conflicts with earlier rights. So that's the conflict with earlier rights. At page 303, there's relative grounds for refusal in Article 8, and over the page at Article 8.4, opposition by the proprietor of a non-registered trademark or another sign used in the course of trade of more than mere local significance. Trademark applied for shall not be registered where, and to the extent that, pursuant to union legislation or the law of a member state governing the sign, rights to that sign were acquired prior to the date of application for the registration of the EU trademark, or the priority claim from that application for the registration of the EU trademark. That sign confers on its proprietor the right to prohibit use of a subsequent trademark. So that's the earlier right. And then in Article 60, (1)(c), we have relative grounds for invalidity. The EU trademark shall be declared invalid on application of an office or on the basis of a counterclaim in infringement proceedings. At C, where there's an earlier right referred to in Article 8.4 and the conditions set out in that paragraph are fulfilled. And then in Article 61.2, we have limitations in consequence of acquiescence where the proprietor of an earlier national trademark or another earlier sign referred to in Article 8.4 has acquiesced for a period of 5 successive years in the use of an EU trademark in the member state in which the earlier trademark or other earlier sign is protected, whilst being aware of such use, he shall no longer be entitled on the basis of the earlier trademark or other earlier sign to apply for a declaration that the later trademark is invalid. So that's invalidity. And then Article 137 on page 352 under Section 2, application of national laws for the purpose of prohibiting the use of EU trademarks. Prohibition on the use of EU trademarks. This regulation shall, unless otherwise provided for, not affect the right existing under the laws of the member states to invoke claims for infringement of earlier rights within the meaning of Article 8 or 62 in relation to the use of a later EU trademark. In the next sentence, key one, claims for infringement of earlier rights within the meaning of Article 8.2 and 4 may, however, no longer be invoked if the proprietor of the earlier right may no longer apply for a declaration that the EU trademark is invalid in accordance with Article 61.2. So, more spread out, but the same approach. And then if we turn over to Article 138, we say the same approach is applied to rights applicable to particular localities. So the proprietor of an earlier right which only applies to a particular locality may oppose the use of an EU trademark in the territory where his right is protected, so far as the law of the member state concerned permits. But Article 138.2, paragraph 1 shall cease to apply if the proprietor of the earlier right has acquiesced in the use of the EU trademark in the territory where his right is protected for a period of 5 successive years, being aware of such use, unless the EU trademark was applied for in bad faith. For comparable trademarks, IR, those two provisions find their equivalent in section 48 once the mark becomes a comparable trademark after Brexit. So after that canter through, actually, may I take you just to Article 189, because then we don't have to come back to it. This is the article that gives effect to the Madrid Protocol. So, an international registration designating the Union shall, from the date of its registration pursuant to Article 3.4 of the Madrid Protocol, from the date of the subsequent designation of the Union pursuant to Article 3 of the Protocol, have the same effect as an application for an EU trademark. 2. If no refusal has been notified in accordance with Article 5.1 and 2 of the Madrid Protocol, or if any such refusal has been withdrawn, the international registration mark designating the Union shall, from the date referred to in paragraph 1, have the same effect as the registration of a mark as an EU trademark. And then Article 190 deals with the two kinds of publication that we were talking about. And at Article 192, if no refusal of protection of an international registration designating the Union has been notified in accordance with Article 5.1 and 2 of the Madrid Protocol, or if such refusal has been withdrawn, the office shall publish this fact, and where applicable, the date of publication of such a registration in the Gazette published in the International Bureau. So that then covers the same ground as we have in relation to the UK legislation. In my submission, the policy in the Act and each of the directives and in the regulation in relation to limitation by acquiescence is first of all underpinned by the importance of legal certainty, set out in the recitals of the directive. And secondly, applied when there has been, when the proprietor has knowingly tolerated the use by the subsequent trademark registrant for a substantial length of time. My submission, and I'll take you to the explanation of this by the Court of Justice in Hightech, there are six things that we can get from the objectives. The first is that these provisions are there to strike a balance between the interests of the proprietor of a trademark in safeguarding the essential functions of the trademark, which are to guarantee the trade origin of the goods, and the interests of other economic operators. So there's a balance going on. You might say, well, what are the interests of other economic operators in having a trademark that is like somebody else's? Well, if you're a company like Ice Group and you've worked on building up a market and goodwill under a logo and a name for specialist goods for 5 or 6 years and then beyond, if you're stopped by the trademark proprietor who has acquiesced in that use for more than 5 years, knowing of the use, you can effectively have not only your goodwill destroyed, but actually taken over. That's an observation that Lord Justice Jacob makes when in his referral to the Court of Justice in Butler. So, by allowing people to be on the market using a trademark that you say infringes your rights, you create an unfairness that needs to be balanced by the legal regime. Second, the regime limits protection to trademarks provided to proprietors who are sufficiently vigilant by opposing the use of signs by other operators which are likely to infringe its mark. Thirdly, the provisions safeguard the legal certainty for users of the registered trademarks who invest in a brand, this is the second registrant, so that they know after 5 years of use an earlier proprietor was known about, they're not going to be stopped and have their mark invalidated. So that gives rise to legal certainty for them, rather than the constant and everlasting uncertainty despite their investment. Fourth, there's an element of public protection as an aspect of the policy. It's a proprietor's job to police and enforce their rights in trademarks, but trademarks provide a public function by allowing the public and the market for the goods to distinguish between different suppliers. Sometimes said so as to reduce search costs. My Lord Justice Arnold said that in King. It also reflects, as part of that public protection, that members of the public can be educated about marks that at first sight seem the same, so that people know that Ice Ramble is Ice China, as the claimants referred to the defendants in 2016. And fifth, that the concept of acquiescence in the directives and the regulation has the same meaning. That if a proprietor of an earlier right remains inactive, even though it's aware of the use of a later trademark, which it would be in a position to stop, and it's acquiesced by failing to take the measures open to it to remedy that situation, then that's exactly what the legislation is aiming to sanction. And notice that all of those points make practical sense if they are directed at use of the mark on the market. Because all of those policy objectives are met if somebody knows about a competitor on the market and doesn't stop them. But the legislation provides it's only a protection that's provided by the user of a registered trademark. The ability to stop that kind of interloper does not depend upon knowing whether or not they have a registered trademark. And therefore, the conclusion is that the proprietor of an earlier trademark or right is time barred from seeking a declaration of validity or opposing the use of a later trademark which has been applied for in good faith if he's acquiesced for a continuous period of 5 years in that use in the marketplace, not some abstract knowledge of a registration of the trademark. Now, in order to make that good, in my submission, I'd ask you to turn to HITECH, which is Judgment of the Court of Justice at Authorities Bundle A1.1, tab 7. I'd ask you to read the head note from pages 234 over to 235. So you'll see that the Bundesgerichtshof referred 3 questions. First one was to do with whether acquiescence can be excluded only by means of an administrative or court action, or is there also conduct involving a court or administration authority. Second was, does a warning letter stop time running? And the third was, when seeking judicial redress, is it significant that the receipt of the action by the defendant is delayed beyond the expiry of the 5-year limitation period? And fourth, what rights are then limited? And the answer are that a warning letter in one, without by which the proprietor opposes the use of a later trademark without taking the necessary steps to obtain a legally binding solution, does not stop acquiescence and consequently does not interrupt the period of limitation. Secondly, that limitation in consequence of acquiescence referred to may not be prevented by bringing in court action if where the application initiating proceedings, although filed before the date of expiry of the limitation period, did not, owing to a lack of diligence on the part of the applicant, satisfy the requirements of the applicable national law for service. And third, that where the proprietor of an earlier trademark or earlier right within the meaning of those provisions is time barred from seeking a declaration or later mark, then the proprietor is also time barred from bringing ancillary or related claims, such as claims for damages and the provision of information or the destruction of goods. Now, in reaching that conclusion, the court analysed the nature of the acquiescence defence, and from paragraphs 47 through to 57 set out the objectives, the purposes in turn. I beg your pardon, paragraph 46 through to 57. Could I ask you to read those rather than trying to read them out to you, and then I'll just highlight some points. So in paragraph 46, we have striking the balance between the interests of the proprietor and the interests of economic operators having signs capable of denoting their goods and services, including those building up goodwill and so on. In paragraph 47, we have protection being provided to a proprietor who shows itself being sufficiently vigilant to oppose the use of the signs. In paragraph 48, we have the safeguarding legal certainty, so that if there's been acquiescence and you've applied for a mark in good faith for a continuous period of 5 years, then there's going to be a certainty in the law that you can't be challenged, and that's both in relation to your registration and your use. And then in paragraph 49, the hallmark of acquiescence is inactivity, being aware of the use of a later trademark. And then then at paragraph 50, the proprietor of an earlier trademark or earlier right is time barred from seeking a declaration of validity or opposing the use of the trademark that's been applied for in good faith, where the period of 5 years consecutive use has taken place, being aware of that use. And in my submission, that strongly supports the view that this is all to do with use on the marketplace. Then the later provisions, paragraphs 52 through to 57, go to issue 3, which is when the what brings the limitation period to an end. So that In my submission, I've given you the reference in the skeleton argument to the Advocate General referring to there being a new opportunity for the court to define the scope of the legal regime. In my submission, that's what the court is doing. And it sets out those principles in a clear way. Now, that needs to be seen in the context of what was said in Budvar, don't need to take you to, which is a probanda which includes knowledge of the registration, but also in the context of the trademark law in the Board of Appeal that came before that. And that is at bundle A1.1 tab 1, starts off with Ghibli. And we're criticised for relying upon this because it's in the Board of Appeal of the EU IPO. And it's said that because the rules of procedure in the EU IPO somewhat different and not treated as a court to which the right to a fair trial applies, that somehow this analysis of the law isn't helpful. In my submission, of course it's not binding, but it is carefully reasoned, principled analysis by an expert tribunal, and it gives rise to the inconsistency between the General Court and the European Court of Justice that we see in Budvar. And given that this contains analysis and reasoning, and in my submission Budvar on the key point of knowledge of registration does not, it is useful. You'll see this is A1.1, tab 1, page 3 for the summary of the facts. Ghibli SPA was proprietor of the trademark Ghibli with some graphics around it, filed on 20th of April 2000. Adolfo Cristanini filed a request for declaration of validity, and it was based on the mark ending 127 for Ghibli in a different graphical representation, and the word mark Ghibli. You'll see that they're registered in relation to machines and machine tools, cleaning for professional and industrial purposes, and apparatus for steam generating, so far as the first mark is concerned, and industrial hot water and high pressure polishing machines for different applications in class 7, so far as the Mr. Cristanini's first mark is concerned. And the second mark was claimed to be a well-known mark. You can see that in paragraph 7 that the allegation is there's going to be a likelihood of confusion, and in paragraph 8, CTM proprietor relied on the defence of acquiescence in use within the meaning article 53.2. And there's submitted proof of existence of an ownership of Italian trademarks, and claims that the Ghibli mark had become internationally well known. The parties even had extensive commercial relations with each other. And the argument here was whether Mr. Cristanini had knowledge of the specific registration in question. The relevant passage is from paragraph 37 on page 22 through to paragraph 47 on page 14. I fear the sensible thing is to ask you to read it again.
Sorry, which paragraphs?
Paragraph 37 to 47, that's pages 12 to
Would you like us to read those?
14. from that very clear message that knowledge of the registration isn't required, but it's not just pumping for an answer. Very closely reasoned, based on principle. So you get from paragraphs 37, which sets out the statutory acquiescence provision, acquiescence by limitation provision, 38 through to 41, the factual situation, so that the cancellation applicant's interpretation of the CTM proprietor would be required to prove not only the cancellation applicant was aware of the use of the contested CTM, but also knew for at least 5 years that the sign had been registered as CTM. And then the rejection of that for reasons, the board's view, the interpretation would be contrary to the objective pursued by Article 53.2 CTMR. This provision pursues an objective which is to create legal certainty by the protection of protecting the legitimate interest of a CTM proprietor in the continued undisturbed ownership and use of its CTM vis-à-vis the proprietor of a prior right who, despite having been aware of the long-term presence of the conflicting trademark on the market, took no action to prohibit that use. In other words, the provision is a sanction of the cancellation applicant's undue delay in exercising his trademark rights whilst being aware of the long use of the later conflicting mark. Considering the said underlying objective, Article CTMR, or 53.2 of CTMR cannot be construed as requiring knowledge of the registration, but only of the use. So what you see there in the legitimate interest is the first question in high-tech, legal certainty. I beg your pardon. The striking the balance with the interest of the trademark owner and the legitimate interest of the proprietor. After that, in other words, the provision is a sanction. That's the second limiting protection to those who are sufficiently vigilant in high-tech. And then legal certainty comes first in that paragraph. And it's explained that those objectives are inconsistent with knowledge of the registration. Then in paragraphs 43 onwards, there is dealing with the linguistic interpretation that references to use of a later trademark whilst being aware of the use, not of the registration. And in paragraph 44, that's made explicit in relation to being aware, not saying being aware of such registration and use in the legislation. Then moving on through to draw the distinction between knowledge of the use of the mark and in paragraph 47, the registration being the objective circumstances that the sign, the use of which has been knowingly tolerated, must have existed for at least 5 years as a CTM. So that's the distinction that's drawn. And that distinction is then reflected in the guidelines for examination of the EU IPO, as well as in cases that in the EU IPO that rely upon Ghibli. My learned friend introduced what's now page 18.2, the introduction. So I'll deal with that. The Office's current trademark and design practice is reflected in a series of guidelines that are intended to be of practical use to those Office staff in charge of various procedures and the users of the Office services. They're revised on a yearly basis. Guidelines in the third paragraph are the main point of reference for users of European Union trademark system and the community design system, and for professional advisors who want to ensure that they have the latest information on our examination procedures. They have been drawn up to reflect our Office practice in the most frequent scenarios. The Office's guidelines are not legal acts, but self-imposed rules of conduct. So what it does tell you is it's an expert guide to the practice and procedure, so that when we come on to page 24, of this text, which is the 31st of March 2023, and you read acquiescence in 4.5.2, you see the approach that is assimilated from the case law. Acquiescence in use of a contested EUTM, first paragraph. Penalised the proprietor for acquiesced for a period of 5 successive years by excluding them from seeking a declaration of invalidity. That's in a case called Antonio Basile, T13309. Then an explanation that the period of acquiescence starts running from the time the proprietor of the early mark becomes aware of the use of the later trademark, but necessarily must be later than the registration of the contested EUTM. It is at this point the proprietor of the early trademark has the option to not acquiescing in its use. And then over the page, the analysis is taken from Ghibli. Proprietor of the contested mark cannot be required to prove, in addition to the invalidity applicant's awareness of the use of the contested EUTM, that the invalidity applicant was also aware of its registration for the 5 years as EUTM. The reference in Articles 61.1 and 2 EUTMR to acquiescence in the use of a later trademark merely refers to the subsequent requirement that the later sign must have been registered as an EUTM for at least 5 years. This is an objective requirement that's independent of invalidity applicant's knowledge. So what you have is you have Ghibli that's decided on the 21st of October 2008. You have these current guidelines that are published on the 31st of March 2023. And we've given you at page 30 through to 42 the guidelines from the 1st of February 2020, which contain the same commentary, so that it's been in place for some time. That's at page 37. And you'll also see that at page 41 in the previous draft from 2020 and at page 28 in the current draft, there's also a little case summary of Ghibli that gives you the same analysis. Now, in response to the criticism that, well, that's a single old case not followed in the courts, in our supplemental skeleton, we provided at A3 tab 38, Turk, Harver, Yolari and the EU IPO in the General Court. And that...
Sorry, what paragraph of your supplemental skeleton? Or page number, either will do.
I beg your pardon. It's page 238 of the bundle.
Thank you.
Paragraph 13 over the page.
So is Turk the most recent word from the General Court on this subject?
Of which I am aware.
Yeah, it's hard to keep up,
hard.
I know.
And also to try and comply with the citation of authority practice direction. And it finds a way into the slight oddity of situate the case law in the Court of Justice. So this was a case that was mainly about likelihood of confusion, as Head Note 2 says. It's decided on the 27th of January 2021. It's reported in the 2021 European Trademark Reports 28. At Head Note 3, the General Court held there was a likelihood of confusion and there was no infringement of the obligation to state reasons. That's how it dealt with the appeal. Head note 27 on page 152 is a summary of how the court dealt with acquiescence, alleged limitation of the application for declaration of invalidity. You can find it just as well on page 160, paragraphs 48 to 49. So, fourthly, the applicant's argument alleging limitation of the application for contested mark cannot succeed. It must be observed that in accordance with Article 54.1, the regulation, the proprietor of an earlier EU trademark has acquiesced for a period of 5 successive years in the use of a later trademark in the Union, whilst being aware of such use, the proprietor is no longer entitled, on the basis of the earlier trademark, to apply for declaration that the later trademark is invalid in respect of goods or services for which the later trademark has been used, unless the registration of the EU trademark is applied for in bad faith. So that's citing the legislation. It follows that there are 4 conditions must be satisfied before the period of limitation in consequence of acquiescence starts to run. First, that the later trademark must be registered. Second, that the application for registration must have been made by a proprietor in good faith. Third, that the later trademark must have been used in the territory where the earlier trademark is protected. And fourth, the proprietor of the earlier trademark must have been aware of the use of the trademark after its registration. So that's taking things in chronological order, logical order. And the citation for that is I Marchi Italiani and Vastili Ohim T1.
Here one bumps one's head against the usual problem that the General Court is in the habit of citing its own case law and not the applicable case law of the Court of Justice.
Indeed.
This is a common problem.
It may be a common problem, but in this context,
it doesn't detract from the force of the authority.
It doesn't detract from the thought. It also suggests that there may be a deliberation about it.
You mean they're deliberately ignoring the Court of Justice in this instance?
In this instance.
Well, how does one know that when it's their habit, even when they are in fact applying the same principles?
Here, it's really different. I mean, Taylor Wessing publish on this different websites. It's really difficult to imagine that the General Court doesn't know about this issue.
Yeah, all right.
And
shall we move on?
Well, I need to show you how it plays out.
Yes, of course.
Because it raises the eyebrows that your Lordship just raised.
Yeah.
All the more. So the case that is cited is the Basili 1 T13309 that I mentioned before being referred to in the guidelines. And that's at tab 40. It starts at page 177. We note that its date is the 28th of June 2012. And we note at paragraph 31 on page 183 that the 4 conditions, according to the terminology that's used in Turk, Hava, Yolari, are set out.
Yeah.
But citing Budvar,
which is not authority for that proposition.
Well, it's not authority for the 4th one. But that was on appeal from the Board of Appeal at tab 39, which on page 170 and paragraph 18, this was on the 9th of January 2009, just a few months after Ghibli.
Yeah, and unsurprisingly, the second board followed itself. Yeah.
Cites Ghibli for it. And then, curiouser and curiouser, when on appeal that didn't really need to deal with this point to the Court of Justice, at page 197, The General Court is said to have got it right, in paragraph 53, because 4 conditions must be satisfied in order for the limitation period to run by acquiescence in the event of the use of a trademark identical to the earlier marks. These conditions include the fact that the earlier trademark must be registered, as well as the fact that the owner of the trademark must be aware of the registration of the latter mark.
So that's a misstatement of what the General Court said.
Citing Budvar.
But it's an accurate statement of what Budvar
says.
So, it's a complete mess. And obviously, if we were still an EU member state, I would have thought, probably have to refer. But we can't refer, so what do we do?
Exactly. My submission, the answer to that lies in the fact that this feature of the decision in Budvar is not part of its ratio decidendi according to the English approach to precedent.
But why is the English approach to precedence of any relevance when the Court of Justice doesn't follow it?
So there are 2 reasons that it's relevant to the arguments now. First of all, my learned friend relies upon Young and Bristol Aeroplane to say that because Budvar was cited in Coombe, this court is bound.
Yeah, well, that's obviously wrong because the point wasn't an issue.
Exactly.
It's simply a recitation of what the court said.
So then the question is, what does this court do when exactly the same kind of problem arises in the Court of Justice decision pre-Brexit? And my submission is it's a strong pointer to either the court not being bound, or alternatively that it should depart, or depart in the sense of do the reasoning itself, and then it actually departs if its reasoning comes to a different conclusion. Where the decision of the Court of Justice, which pronounced this probanda, this prerequisite, did not engage with the issue at all. Firstly, because it wasn't an issue on the appeal. Secondly, because the Advocate General said it was unnecessary for decision. And thirdly, because the Advocate General who formulated the wording received no submissions in relation to it, no submissions in relation to the reasoning in Ghibli, and provided no reasoning for the introduction of those words to the 4th prerequisite. And then the Court of Justice adopted the wording of the prerequisite, again without any analysis or reasoning. And in my submission, that's also why the debate about is it obiter per incuriam or just not part of the ratio is pretty arid. And in my submission, I found the much better answer in the case law provided by Actavis and Merck, Bilter and Traditional Finance Services, Halsbury's Laws, and are in the ex parte Cadim, the Brent London Borough Housing Benefit Review Board, than in my first Skeleton argument, which a learned friend criticised for the technical analysis of what's obiter, or in particular what's per incuriam. But the vice that's involved here is exactly the same.
Well, I think you accept that the test that we have to apply is that in the 2018 Act,
Yes.
viz. That it's the same test applied by the Supreme Court under the practice statement.
That's right.
So the question is, and you've given a number of reasons for saying that the force of the decision is slight because it's assertion, not reason. And I understand those submissions, but even so, it doesn't necessarily follow that the criteria under the practice statement are satisfied. And so I think we need to be persuaded on that.
Might that be a good time to stop so that you can ponder that over
Yes.
night?
Absolutely. And then I have to crack on in the morning.
I think that's right.
And one of the things that occurred to me from that latest exchange is that I don't need to repeat the submissions in relation to per incuriam and so on. You've got my submissions and the law, and I rely upon it. I particularly rely upon the supplemental skeleton, and then I need to persuade you in relation to departure from that.
Well, where are you on timing? Because there's still quite a lot to get through.
Yes.
How much longer will you be?
I think I'm going to be another couple of hours.
What,
Well,
with
how
the
is that going to work?
With your first round of issues, and we have a reply, then you have your second round of issues, then another reply.
Try and do it in an hour.
Well, we have to finish
Yes.
tomorrow. There's no question of us being able to go beyond tomorrow.
Absolutely.
My lord,
Yes,
that was
Mr.
precisely the point I was going to say. Might my lords, may they consider imposing a guillotine in 1 hour then?
I would prefer not to impose a guillotine. I'd prefer counsel to, when you're both grown-ups, I would prefer you to arrange it between yourselves, but I'm sure you will want to be fair to Mr. Campbell.
Of course.
So take our reassurance, Mr. Campbell, and if I need to impose a guillotine
Thank
in
you.
due course, I will. But I'm sure I won't need to. But we do need to move on. I mean, we've been assisted because I think it will have been of use to you that at least we've been through all the regulations, the directives, and the.
Yes, we have.
Actually, no doubt you'll have to highlight things, but you won't have to go through them all again.
Yes, thank you.
Very well. Thank you very much.
All rise, if able.